Welcome to this course in Real Estate Regulatory Act. Birds build a nest in 3 days, and humans have to spend at least 3 months to understand Rera. The good news is that Rera has lot of scope to grow the practice of lawyers, engineers, accountants, and of course the bureaucrats. So let's understand it, to encash this new opportunity. Before we dive into the details, it's worth noting that lots of people saved money for 2 or 3 decades to buy a home. These innocent home buyers failed to understand the fraudulent currents that run in the real estate industry. These currents are discussed in detail in our contract design course and in our real estate course. So the dirty developers cheated the innocent home buyers who had saved and sacrificed their joys for a number of years, hoping to have their own shelter above them. Lot of tears, frustration, litigation, and depression hit mankind before Rera was conceived. Reading a law multiple times provides. When a law is read multiple times, and its various portions are linked up, then the entire design of the legal framework gets mastered, and you begin to think beyond the people who framed the law. I always trust that smart lawyers see the loopholes as they read a law. A common man spends his time in understanding a law. A lawyer spots the loophole and scans the entire law to be sure he can hide or protect the loopholes forever. This is a tough procedural section, and for lawyers, clerks and bureaucrats this section has all the cheese, butter, and meat below the red tape. This explains the various details to be included in an application. Firstly, a profile of the developer, its name and address, then about the structure of the developer, company, partnership, society, etc. has to be stated, and the registration certificates have to be provided. Most important, the photos of the promoters have to be added. I think they missed adding the biometric identity card and passport number of the promoters. Secondly, details of all projects done by the developer in last 5 years, current status of those projects has to be declared. Developers also have to declare their kin of worms in those projects, like delayed completion and pending court cases. They also need to declare about their ownership and equity in the land being developed and the payments pending for gaining that land. In case they are reapplying for registering this project, then it has to be declared. Oh, take a few minutes to read this entire slide, in case you want to get into the documentation for Rera compliance. Rera body will ask you more documents than your clients. You need to attach all the municipal approvals and commencement certificates. In case it's a multi-phase project, then you have to attach the plan approvals and commencement certificates of all the phases. You need to attach the sanctioned plan, layout plan, and specifications of the proposed project or that phase. Then attach your plan of development works to be executed in this project and proposed facilities to be provided like firefighting facilities, drinking water facilities, emergency evacuation services, use of renewable energy, etc. Then state location details of the project, with clear demarcation of land along with its boundaries, including the latitude and longitude of the endpoints of the project. I know most of you are thinking that your laws never bothered to ask you so many details. Haha. Then provide a copy of the allotment letter, agreement for sale, and the conveyance deed you will be signing with the buyers of your apartments or plots. Then for each apartment you want to sell you have to state its number, type, and the carpet area along with the area of the exclusive balcony or veranda areas and the exclusive open terrace areas. Then you declare number of garages and the areas of each garage for sale in the project. You need to declare the names and addresses of the real estate agents who will be marketing this project. Developers shall declare the names and addresses of the contractors, architect, and structural engineer, if any. Developer shall declare that he has a legal title to the land. On a comprehensive affidavit, the developer shall make the following declarations. Developer shall declare that land is free from all encumbrances, or declare the entire list of encumbrances has to be listed. The completion time of each phase has to be stated. That 70% of the amounts from apartment or plot buyers shall be deposited in a separate account in a scheduled bank to cover the cost of construction and the land cost, and shall be used only for that purpose. Mostly, all the big nationalized banks are scheduled banks, but you can ask the accountant of any bank and he will tell you if his bank is scheduled or not. The law has allowed the developer to use 30% of the funds without any explanation. This margin is huge for a dishonest developer. Section 4 KLD has 3 provisos. Proviso 1. Promoter shall withdraw the amounts from that account in Schedule Bank, only to cover the cost of project, in proportion to the percentage of completion of the project. Proviso 2. The withdrawals shall happen only after it is certified by an engineer, an architect, and a chartered accountant in practice that the withdrawal is in proportion to the percentage of completion of the project. But if the developer pays a high retainer fee to my engineer, architect, and accountant, they will oblige and certify most acts of the developer to be in accordance with law. Proviso 3. Promoter shall get his accounts audited every financial year by a chartered accountant, and shall produce a statement of accounts and a certificate from the chartered accountant that as per his audit that amounts collected for a particular project have been utilized for the project and the withdrawal on date matches the percentage of the project completed on date. I repeat, certificate should state that the developer's withdrawal on date matches the percentage of the project completed on date. I repeat, certificate should state that the developer's fund withdrawal on date matches the percentage of the development completed on date. You got to note that the developer still has 1 year to set right his bad dishonest financial management. Now the catch is most chartered accountants are not technically trained to assess the completion of the project in terms of assessing quantity and quality and the tasks remaining. So the developer still has enough scope to manipulate. There is a catch here: swearing a false affidavit amounts to perjury. But still the courts and the police are somewhat okay if they come across any false affidavits. Until the judicial and criminal machinery is trained to detect false affidavits and issue warrants based on false affidavits, a powerful developer can somehow find ways to escape. Moreover, this section has no meaning for developers who are politically well connected and they can easily influence an untrained government machinery. Further, the affidavit shall also state that developer shall take all the pending approvals on time from the competent authorities. Developer has furnished such other documents as may be prescribed by the rules or regulations made under this Act. Now the catch is, when a lawyer drafts such a long affidavit, even the Indian courts take a couple of years to find the loopholes in that affidavit. How fast the Rera authorities will catch these loopholes? Even if they detect these loopholes, what is the incentive for them to oppose such a loophole? The law does not specify what consequences the authorities face if they act complacent. This tooth is missing in this law. The authorities shall enable online posting of applications for registration of projects within 1 year.